it's a really exciting series of panels. And obviously this conference is organised by CFAR and the International State Crime Initiative, which is based in the University of Ulster and Queen Mary and Northumbria. And we're really delighted to be hosting these conferences with our friends at CFAR. And it's a really timely topic. I think kleptocracy and asset recovery is definitely a major thematic today, and especially as the byline of the conference, the role of destination countries. And I really, just before we kicked off and in a brief conference introduction, I just wanted to kind of maybe kind of reflect on the conference theme very briefly before I hand over to Jackson to begin the first session. And I think, you know, when we hear a concept like the role of destination countries, I think it kind of comes against a certain background. And I think when it comes to corruption studies, where historically we've tended to think about corruption through the prism, through the lens of the nation state. And, you know, so we think about corruption in you know, not to pick on any one country, but in Malaysia or in Uzbekistan or in the United Kingdom, to use a more recent example. And yet what we know from the majority of the empirical research into grand corruption, at the very least, and its connected kleptocracy, is that actually whilst the victimization certainly takes place within a nation state, the networks that organize this victimization on a transnational scale. And there's a very important reason for that. They get to take advantage of often the best of both worlds. So I do a lot of my own work and research in Central Asia. And there we see examples of, on the one hand, authoritarian regimes being able to plunder the national wealth in the interests of the ruling families. And then they are able to export that wealth and manage that wealth abroad in secret, secure financial havens, of which the UK is a leading example, and its overseas territories. But we could easily also point to Switzerland or to the United States. And that actually becomes a doubly corrosive dynamic. On the one hand, corruption and kleptocracy, obviously kleptocracy helps to anchor authoritarian regimes, but also when their money goes off and is used by our financial sectors in places like the UK, it also helps to deepen the influence and the control which the financial sector has. And that has been shown to have a corrosive impact on democracy and on public policy in places like the UK and Switzerland. So I think, you know, when we talk about corruption, we talk about destination countries, and we talked about, we are actually working in solidarity. Our friends and colleagues who are working in what we might term the global south, they have an interest in tackling these issues because their wealth is being looted, but also those of us who are working in the global north also have an interest in these issues, because that looted wealth is then priming a lot of problematic forces in our own regions. And so I think on that note, we'll, bear with me, and just to note, because we're on the Zoom regular version, we will be muting people as they come on, but there may be a brief lapse where we can hear people, and then they'll be muted by the conference organizers. So I think there is a real scope for solidarity in this area of asset recovery. We all have a shared interest in tackling looted wealth, and particularly when it's stored in the financial centers of the world. And so, and as you can see from all the panels today and tomorrow, and I hope everyone can attend these fascinating panels. There's really cutting edge research being done both within the academia and civil society, and we're really beginning to learn a lot from this about the strengths of asset recovery and tackling kleptocracy, and some of the weaknesses as well. And I'm sure we'll learn a lot more about that today. So on that note, can I just again warmly welcome everyone. It's fantastic to have you all here, and I will now pass over to my colleague Jackson to kick off the conference as well and take us into the first session.
Thanks so much, Chris, and I mean, thank you also for the great collaboration on this over the last months. We're also really excited to have this conference today and tomorrow. I mean, I think there's going to be lots of great speakers and lots of great discussions as well, hopefully. So we're really excited. I mean, it's also for us super interesting to have this event, which brings together academics, civil society, and people from across the world to talk about these issues. And I just want to reiterate the points you made about the importance of this topic, and especially of considering it from the perspective of also the global north, which is often not the perspective that we tend to focus on, as you said, Chris. So yeah, I don't want to take up too much time, and I really want to get into the topic. So what I would propose now then is to kind of change my hat from this welcome to everybody and step straight into the beginning of this first session. So the session we're kicking off with today is entitled Models of Asset Return, and we have four great speakers and three great presentations coming up that discuss different aspects of this. So we're going to start with, one thing I want to mention as well is that we're recording this because we want to also make this available to people that can't attend the conference today. So if you have any issues with it being recorded, please feel very free to keep yourself with the camera off. We'll also be collecting questions at the end of the session, and if you want to pose a question or to write a comment, please do that in the chat, and we'll collect these together at the end. But yeah, so turning to our speakers for today. So to start with, we have Dr. Cecily Rose, who is an assistant professor of public international law at Leiden Law School in the Netherlands, and whose research is in the area of transnational criminal law, focusing on international legal approaches to corruption, to asset recovery, organized crime, and money laundering. Dr. Rose has also worked as a consultant for the UN Office of the High Commissioner for Human Rights, the World Bank, and UNODC. Her presentation today will be on a human rights perspective on asset recovery, which is raising some questions around how states can and should fill the gaps left by the UNCAC's asset recovery provisions in a manner which both furthers the goals of UNCAC and upholds international human rights law. Secondly, we'll have a presentation by Sarah Brimbuff and Rahima Ratoumi. Ms. Brimbuff heads the Illicit Financial Flows Programme at Transparency International France, and has been leading TI France's advocacy efforts on asset return for the past 3 years, as well as coordinating TI France's strategic litigation on illicit ill-gotten gains and foreign bribery cases. Mr. Toomey is a trainee lawyer at the Paris Bar, and she joined TI France's Illicit Financial Flows Programme from January to December 2021, and worked on illicit financial flows, strategic litigation, and asset restitution. Their presentation today is entitled Towards a French Model of Asset Return, and discusses the newly developed French law on asset restitution, which enshrines principles developed at the Global Forum for Asset Recovery. This presentation will discuss the key issues that went into this and avenues to ensure that the GFAR principles and use of returned assets for the benefit of victims are systematically implemented in future restitution processes. A draft version of this paper will be added to the chat, so you can also follow along with that. And finally, we will conclude with a presentation by Dr. Simeon Igbinedion, who is a senior lecturer at the Department of Jurisprudence and International Law at the Faculty of Law in the University of Lagos, Nigeria. His core area of research includes corruption, money laundering, asset recovery, and repatriation to victim states, and he is currently consulting for Nigeria's Independent Corrupt Practices Commission on illicit financial flows. His presentation today is entitled A Case for a New Model of Repatriating Recovered Assets to Original Owners, and questions the idea that victim state officials faithfully represent their state's interests. Instead, his presentation will explore the idea that assets should not be repatriated to their victim state where there are serious concerns over corruption or a lack of adherence to its high-profile officials to the prudent management of state resources. I'm really looking forward to each of these presentations. Each presenter will have around 20 minutes to present. And then, as I said, following this, we will open the floor for questions and comments. So please add these to the chat. So without further ado, I would like to hand the floor over to Dr. Cecily Rose, who will begin our session today and our conference in general.
Okay, thank you very much for that lovely introduction. And thank you to Christian and to Jackson for inviting me to participate in today's event and for organizing it. What I'm going to do is first begin by talking about the current state of the law on the return of assets. And I'm going to talk also about what's missing from this legal framework, the need for reform, and then I'm going to critique the present situation from the perspective of public international law and in particular human rights law. And I hope that by setting out this legal framework to begin with, this will also be a helpful way to sort of open the conference. So I'm speaking then in particular about the UN Convention Against Corruption and specifically Chapter 5, and more specifically, Article 57, which deals with the actual return of assets. So I'll just begin then by saying that, of course, UNCAC, the UN Convention, is the only anti-corruption treaty that addresses asset recovery to any significant extent. And we can see it in a sense as a major accomplishment back in the day, in 2003 when it was concluded. So UNCAC makes asset recovery a fundamental principle of the treaty and devotes an entire chapter to this particular issue. Now I'm focusing specifically on Article 57, which deals with return. So then I'm skipping the stages of tracing, freezing, confiscation, and bringing us right to the very end. And I'm doing this for a number of reasons. One of which is that this was a particularly controversial article within a chapter of the convention that was as a whole controversial. And the limitations of Chapter 5 and Article 57 in particular are partly a product of the politics of the time, and also partly a product of a knowledge gap that existed at the time that the treaty was concluded. So at the time, there were basically two camps among the negotiating parties. So if I'm going to give a sort of simplistic picture of what was going on, developing countries, so countries that are requesting the return, wanted to make sure that they could do so without conditionalities, political conditions, legal conditions being imposed. And they were also interested in ensuring that there would be no sharing of assets among the states involved in these asset recovery processes. Now, on the other side, developed countries, the destination countries, were concerned about the unconditional return of stolen assets, and in particular to countries that have serious corruption problems, and were interested in requiring monitoring and that funds be devoted to specific purposes. And so what I'll describe in a moment about the structure of Article 57 reflects a compromise and very much limits the conditions under which assets must be returned. It's also important to note that Article 57 was drafted in the midst of a sort of fundamental gap about the state of practice. So the major embezzlement scandals of the 1980s and 90s, think for example of Sani Abacha, Montesinos of Peru, Marcos of the Philippines, those embezzlement and asset recovery cases had not reached the return stage at the time that this convention was being concluded. And so I'll talk more later on about the way that this has resulted in some persistent gaps in the treaty itself. Now, it's important also for me to note that we're still in the process of gathering information about how asset recovery works in practice. So there's been obviously a lot of progress since 2003 when the convention was concluded, but the review mechanism that is monitoring the implementation of the UN Convention is actually still in the process of reviewing Chapter 5. So the second review cycle is still ongoing and is supposed to be completed in 2024. So this has been a very slow process. In addition, the World Bank has been updating its research, but as you all probably know, the asset recovery database hasn't been really kept up to date in the way you might hope. And actually right now it's offline altogether. So we have still an incomplete picture, I think, of the practice. So let me now give you a sort of brief overview of the actual legal intricacies of Article 57. So bear with me, I will delve into a little bit of the details here, which I think are important. So first, it's important to know that Article 57 imposes, of course, an unqualified obligation on requested states to return confiscated property to the requesting state, but only under certain conditions. So the first condition is that the funds, rather the state of origin, so the Switzerland, the UK, rather the state of origin meaning Nigeria, for example, that it has to have an ownership claim over the public funds that have been embezzled or misappropriated and also possibly laundered. Now, that means that by definition, then this asset recovery process is mostly excluding the proceeds of bribery. So an ownership claim usually can't be established with respect to an undue advantage that has been paid to a state official. This usually cannot be claimed as the property of the state, even though the bribe may indeed very much have caused damage to the state. So this means that we're, of course, talking about one particular crime of corruption, embezzlement. Now, the other conditions for a mandatory return are that the confiscation has to have been executed in accordance with the provisions of UNCAC that deal with international cooperation. And the confiscation has to have been on the basis of the request has to have been on the basis of a final judgment in the state of origin. So both of these conditions then further limit the circumstances in which the return of assets is obliged under Article 57. So for example, it's very possible that the state of origin hasn't yet issued a final judgment, or that the legal processes have been administrative in character, such that one of these conditions isn't met. So where these conditions aren't met, there's no obligation to return the stolen assets, even where an ownership claim exists. So even where the funds are the proceeds of embezzlement or misappropriation. So that leaves us then in the realm of discretion. There's an obligation only to give priority consideration to the confiscated property being returned to the requested state party, its prior legitimate owners or victims, according to UNCAC. And the treaty doesn't indicate how these various potential recipients ought to be prioritized. And it also doesn't indicate whether certain recipients are off limits, such as, for instance, the development agency of a haven state, such as Switzerland or France. Now, finally, Article 57 indicates that agreements or arrangements for the final disposal of confiscated property can be concluded, but it's not required. And in practice, according to the research of the World Bank, often it's the case that such agreements are not concluded, and I'll return to that point. So this brings me then to the question of what's missing from this picture. What's missing from the legal framework that was created in 2003 as embodied in Article 57? Well, first, as I've indicated, we're missing an indication of how to prioritize recipients. So victims first, or another method. And should funds be directed as a general practice towards special government funds rather than to the general budget for tracing purposes, for example? That's not addressed at all. And what about the practice of non-governmental organizations such as the BOTA Foundation as recipients? So when is this appropriate, and how should that be regulated? And how should the norms that govern recipients in the embezzlement or misappropriation context be different from or the same as the rules that govern those in the bribery context? So bribery and embezzlement raise distinct legal issues in the context of repatriation. What's also missing is an indication of, indeed, the need for a written agreement on how the return of funds should be regulated. So this is not required, but it can certainly be argued on policy and legal grounds. This constitutes a basic step towards ensuring that the repatriated funds will be put to good use. So as I've indicated, World Bank research shows that in many cases, funds are returned in the absence of a written agreement, which I think indicates then that in many instances, funds are being returned without, not only without a written agreement, but perhaps without any agreement as to the use or the management of the returned funds. Now, one other missing element regards transparency. In particular, the publication of the written agreements that do exist. So UNCAC provides for the possibility of agreements and arrangements, but doesn't require it. And I've conducted fairly extensive research to look into how many written memoranda of understanding I could actually find. And the grand number was not large. And some countries, such as the United States, for instance, have developed a practice of not releasing written agreements if they exist, but instead of just issuing press releases. This is the common practice of the US, for instance. So this level of non-transparency is somewhat ironic, given that the UN Convention Against Corruption actually highlights in Chapter 2 of the treaty transparency as a fundamental principle of the treaty. Now, another missing element from Article 57 and Chapter 5 as a whole concerns issues of accountability and participation, and the need, for instance, to prevent the re-corruption of returned funds through monitoring. So the treaty says nothing about monitoring, and indeed this was a very sensitive issue during the negotiations. There were concerns about how this would infringe on the sovereignty of the state of origin. From a good governance perspective, it can be certainly argued that the monitoring of returned funds is a basic precaution for countries where large-scale embezzlement or misappropriation has taken place. But UNCAC doesn't address what the best practices might be then with respect to monitoring and who should monitor and how that should be done. Finally, one last point, one last missing element, and this is not an exhaustive list. There are other things that are missing, but there's also no indication of how disputes about all of this should be handled. So of course, UNCAC does have a provision that addresses the prospect of a dispute that could be brought then to the International Court of Justice. But it doesn't set out, for instance, mediation as an option that could be considered by states when trying to arrange for the return of funds. So the picture that I've painted, I think, is one which really points to the need for reform. So I think we're very much at a point in time where it's obvious that there's a need for further norms to govern the return of assets. The Conference of States Parties to the treaty could fill this need for law reform, but it hasn't yet done so. I think that maybe after the conclusion of the second review cycle in 2024, maybe we can hope and expect that then the working group on asset recovery would undertake the drafting of non-binding guidance. I hope that will happen, but it remains to be seen. So in the meantime, to fill this gap, various sets of principles have emerged. Some of these principles on asset recovery and the return of stolen assets have been state-led, and some have been civil society-led. And I could, there's a lot to be said about this. I'll just focus for right now on the GFAR principles, so the Global Forum on Asset Recovery, and those principles which were drafted essentially with the leadership of the US and the UK, which were the host states for that drafting process, which essentially took the format of a conference at which, as I understand it, 28 states were represented, and then there were also civil society participants. I would be curious if anyone in the audience was present for that event to hear your perspective on what that was like, what your experience was. But briefly, the substance of those principles, they're brief, and they provide for cooperation, transparency, and accountability, the availability of information about the transfer of assets and the administration of them. There's also principles that deal with the need for participation, the inclusion of non-governmental stakeholders in the asset return process, and there are principles that address beneficiaries being the victims and not the original perpetrators. So just to conclude, I'm going to provide a sort of critique of the GFAR principles from my perspective as someone who specializes in public international law. And the perspective will largely be that of international human rights law. So both the UN Convention and international human rights law provide a legal basis for much of what is set out in the GFAR principles. So, for instance, the UN Convention's chapter on prevention specifically indicates that anti-corruption strategies must be premised on transparency, accountability, and participation of society. Now, this is further reinforced then by international human rights law. For example, the International Covenant on Civil and Political Rights, which provides further legal support for the right to participation in public affairs, as well as access to information. Furthermore, the Covenant on Economic, Social, and Cultural Rights also provides that states are obliged to cooperate with each other for the purpose of realizing economic, social, and cultural rights. And I think that the return of state funds can most definitely has to be characterized as an economic human rights issue. So the point here is partly that anti-corruption law and human rights law are mutually reinforcing with respect to the need for accountability, transparency, and participation. So from that perspective, I think it's unfortunate that the norm development that we've seen, the GFAR principles, lacks a legal basis, that the principles have been produced in a sort of legal vacuum with very minimal references to the convention itself, with some terminology that deviates from that of the convention, and with, of course, no references to human rights law. So then the final question that I'll discuss briefly is whether this matters. So why is it important? Why does it matter that the GFAR principles don't make any reference to the relevant legal framework? Well, I think it's important because the return of assets has to be regarded as not just governed by policy considerations. I think that some of the creative solutions, for instance, that have been put forward by academics have gone too far, have gone beyond the realm of what the law allows. And I'm thinking here, for instance, of the proposals that have been put forth by Jason Sharman, who has argued that in certain circumstances, haven states or private litigators should be permitted to keep confiscated assets. And his point is that confiscation itself serves the goal of depriving the criminal of illicit proceeds and thereby has a deterrent effect and has an accountability aspect as well. Now, I think arguments like that are untenable because they ignore the underlying legal framework, not just the provisions of the UN Convention Against Corruption, but also human rights law. So Article 57 does leave gaps, but human rights law partially fills them. My point then is that Article 57 has to be read in the context of not only the larger treaty, but also as part of the larger field of public international law. So the failure to make basic information available about the return of assets violates arguably Article 19 of the ICCPR, the Covenant on Civil and Political Rights, And the failure to include civil society arguably conflicts with Article 25 concerning the right to participation. So my basic point is that academics and civil society actors have a responsibility, I think, to ground this discussion about what asset return should look like within the relevant legal framework. And I think, unfortunately, GFAR had the effect of separating the law and the policy, but this can be resolved. All right, thank you very much.
Thank you so much. That was a super interesting discussion and a great start to the session and to the conference in general. I mean, I think there's lots of really interesting points to think about there, especially from my perspective as a civil society person who also engages in these policy discussions and often also forgets about the fact that we do have law to fill this gap. And I think there are also many people in the session at the moment as participants who are also at the GFAR, so that can also be interesting when we get to the discussion. Thank you for that, and without further ado, then I will pass the floor to Ms. Sarah Brimboff and Rahima Toumi to go into their presentation, which then looks at the application of the new French model on asset return. I'll pass the floor over to you now.
Thank you very much, Jackson. Good afternoon, everyone, and thank you for the invitation, for allowing us to being here and to present the new developments in France. I will start with some element of background before giving the floor to Rahima for a more detailed presentation of the indicators we have developed at Transparency International Flow. So to start, we can say that in France, the year 2021 was a pretty important one regarding asset recovery. In July, the French Supreme Court upheld Théodore Obiang's conviction from laundering of embezzled public funds. Théodore Obiang is, just for the record, the Vice President of Equatorial Guinea. The Supreme Court also confirmed the confiscation of all his assets in France, amounting over 150 million euros. Just after the Supreme Court's decision, France adopted an asset restitution mechanism, allowing French authorities to return confiscated stolen assets to countries of origin, even in situations where mutual legal assistance or international cooperation were impossible. To say it in other words, where no restitution requests are being made by the origin countries. In situations where, for instance, there is no change of regime in the origin countries, or where there is no particular willingness from the origin countries to prosecute, to investigate on the corruption-related offences that led to the laundering of these funds abroad. The new French restitution mechanism also enshrines principles of transparency, accountability, and principles requiring to include the civil society organizations in the restitution process. So these principles are inspired from the GFAR principles, but not only, also from initiatives from civil society. And I'd like here to emphasize the role civil society organizations have played in France to push for, to advocate for the implementation, the enshrinement, for the enshrinement of such principles into the French law. So these provisions, the enshrinement of principles of transparency, accountability, of inclusion of civil society into the French hard law are undeniable advances. But they are only a first step to building a responsible asset repatriation system in France. Indeed, several questions remain. How can each of these principles be translated into practice? How can we ensure the effective enforcement of these principles throughout the entire restitution process? When we look at past and current asset restitution practices abroad, we unfortunately see that most often transparency and accountability remain unheeded, that civil society organizations remain rarely consulted, and they most often are being left out of the process. When we look at restitution processes abroad, restitution practices abroad, we also come to the conclusion that it is very difficult to distinguish, to draw conclusions, to draw general patterns on what is going on in the asset restitution field. We really struggle to compare restitution practices between each other. One reason is that state practices in this field are highly disparate. There are important discrepancies from one restitution process to another. Even in recent cases, despite all of the discussions that are going on since 2017, since the last 5-6 years, even with countries that have adopted a strong stand with respect to the fight against corruption and kleptocracies. What we can see when we look at these practices, past or current, is that this is often one step forward and 2 steps backwards. And just really brief example, maybe the restitution by Switzerland of confiscated assets to Kazakhstan. Dr. Cecily Rose mentioned the Botha Foundation in her presentation. The Botha Foundation was a philanthropic organization that was chosen by Switzerland and the United States to return 115 million of US dollars to Kazakhstan. And the Botha Foundation is often presented as a successful example of asset restitution. And 2 years later, 3 years after the restitution of the assets through the Botha Foundation, the Swiss returned another 50 million of US dollars to Kazakhstan. And this time they chose another model, another pattern, because the Botha Foundation was considered as was expensive, was being viewed also as an administrative cumbersome. The Swiss decided to go with another channel to return the funds through the World Bank. And we cannot say, I mean, we don't have the full picture, but this choice was criticized because of its lack of transparency, because of the irregularities it conducted to, and because of the identified mismanagement of the assets that were spotted by experts and civil society organizations. So we can see that Swiss orchestrated 2 restitution processes towards Kazakhstan, and in one example it was a success, and in the other example it was described as maybe not a failure, but it was highly criticized. So this illustrates how disparate practices can be when we are talking about asset restitution. And there's many reasons that explain these different practices. One is the lack of the framework that we have is rather general, and as Dr. Cecily Rose was explaining it, the only international text, the international treaty we have is really, lacks to assess and address issues with regard to asset restitution. Other reasons may be that political and economic interests play a big role when it comes to deciding on asset restitution modalities, and interests such as political ones and economic ones may evolve over the year, and situation between countries may change over the year. Those interests, political and economic ones, may also change, may also vary depending on the amount of the asset returned. What is at stake is not the same with a couple of millions, or when we have hundreds or thousands of millions of US dollars on the edge of being returned. In addition to these reasons, we can also mention the lack of experience countries may have when speaking of asset restitution. We can also mention a certain desire from a destination country viewpoint to get rid of the burden of the confiscated assets, the desire to rush the restitution process at the expense of transparency and accountability. So such a context in most of asset restitution practices is highly subjected to external interests. And this makes it difficult to identify guidance and general patterns. As I was briefly saying, the general framework is lacking, and the existing standards are remain rather general, the G5 principles, for instance. So it is therefore necessary to develop these standards and to establish patterns that would guide that would help establishing good practices in asset restitution. This is why transparency, building on, is drawing inspiration from other initiatives from other countries or from other civil society organizations, has developed indicators to evaluate the degree of transparency, of accountability, and of what we call inclusiveness, but the degree of how civil society organizations are involved in the restitution process, to compare these practices between each other, but also to draw and to identify good practices in this field. I will now leave the floor to Raima so she can develop on these indicators.
Thank you, Sarah. So these indicators aim to provide guidance to public decision makers and to practitioners intervening in the repatriation of illicitly acquired assets. They are part of a broader handbook for the responsible return of ill-gotten gains, which also presents a series of good practices for asset restitution as well as case studies. And so TI France believes that practices and procedures for the return of assets should be driven by the goal of asset restitution, that is to return the assets to the origin country, where they should be used for the benefit of its population, which was harmed by the original crimes. So consideration of the interests of victims should really be at the center stage. Because it appears clearly that the mere formal commitment to ensuring transparency, accountability, and the inclusion of civil society is not enough. The indicators that we developed are based on a series of key parameters which aim to take account of the concrete issues raised by the implementation of these principles. So for the principle of transparency, the three key parameters that we had identified are first, conditions of access to information. And here the important questions are, does the public have access to all the information relating to the restitution process? Under what conditions? And is the information accessible in a legible and understandable manner? Second, is the level of detail of publicly available information. So here the question is, what categories of information are publicly available, and with what degree of precision? And third, the timing and frequency of publication. So when is the information available to the public? And these parameters have a very concrete practical implications. So if we take an example with respect to the restitution of assets from the United States to Equatorial Guinea, a very recent case involving Théodorine Obiang, the current vice president of Equatorial Guinea. The agreements concluded between the Department of Justice and Théodorine Obiang provide for the transfer of nearly $19 million for the purchase and distribution of COVID-19 vaccines in Equatorial Guinea, and the transfer of nearly $6 million to Medical Care Development International for the purchase and distribution of drugs and medical equipments. But what is striking in this restitution process is that the information on the restitution, especially on the choice of allocation of the returned funds, was released only after the decisions were taken. So as a result, CSOs could not raise, at least not on time, the issue, for example, that the International Monetary Fund granted Equatorial Guinea an emergency loan of $67 million in September 2021, right before those decisions were taken. So there is therefore a risk in this respect of duplication in the utilization of the funds lent by the IMF and of the funds returned by the United States, which in turn raises a risk of misuse of both these funds. So this illustrates why timeliness is really key in sharing information with the public. So now turning to the principle of accountability, the three key parameters to consider are first, the planning and formalization of the restitution process. So here the main questions are, what are the actors in the restitution process accountable for, and what procedures are put in place? The second parameter is the distribution of roles. And here the question is, who is accountable and to whom can civil society turn for any request or question relating to the restitution? And well, third, the issue of liabilities and remedies. So here the question is it possible for any stakeholder to report potential failures or irregularities? And are there remedies and corrective measures available in the event of such a failure or irregularity? And in this regard, well, we see from past restitution experiences that there is a need for clear procedures, clarity in the responsibilities of stakeholders, as well as specific mechanisms to prevent and correct potential failures or irregularities. So the issues arising out of the recently initiated return of assets to Nigeria from the United Kingdom, Ireland, the US and Jersey to finance infrastructure projects illustrate that, well, these issues in a very striking manner. So there's three ad hoc restitution agreements which were concluded. Well, they generally contain some more or less elaborate safeguards to ensure that the funds do not fall back into the hands of corruptors. However, they do not seem to provide for specific accountability mechanisms. And as a consequence, the issues of concern, well, the issues raised have not been properly addressed so far with stakeholders, including civil society organizations, turning to different fora in an attempt to safeguard the integrity of the restitution process. And these difficulties really illustrate that the need for effective ad hoc mechanisms for handling complaints and alerts is strong. And in the absence of such mechanisms, the various challenges that were made through a variety of channels, well, so far they have been just unsuccessful. And lastly, turning to the principle of inclusion of civil society, the three key parameters to take into account are first, the ability of civil society to act. The question here is, what means that civil society have to participate effectively in the restitution process? And are these means, whether they be human, financial, are sufficient to conduct its actions? The second parameter is the conditions for participation of civil society. And here the question is, to what extent is civil society included in the process? And is it simply consulted, or is it really involved with active participation? And also at what stage this participation happens? And lastly, the third parameter is the selection criteria used to choose civil society representatives. And here the question is, according to what criteria are civil society representatives participating in the process selected? So one interesting example with respect to the selection criteria is, well, the Kazakhstan 1 and Kazakhstan 2 restitutions. So we discussed it already, the Kazakhstan 1 restitution in which the US, Switzerland, and Kazakhstan intervened involved the creation of an ad hoc foundation called BOTA, whose members were selected among Kazakh citizens with known commitment and expertise and presenting guarantees of independence vis-à-vis the Kazakh government. And by contrast, the same standards were manifestly not applied to CSOs intervening in the context of the Kazakhstan 2 restitution. So in that restitution process, in particular, it was highlighted that, many misleading press releases and public statements were made, both from the Swiss government and the World Bank, which led the public to think that the funds were part of Switzerland's development assistance rather than returned ill-gotten assets. But most importantly, that there was also an issue with respect to, the allocation of the funds to a consortium of 3 CSOs that were actually entirely controlled by government. This case really raised the question of the legitimacy of the CSOs participating in a restitution process to act as representatives of civil society, and in turn, the question of what criteria are used to select these representatives. So TI France's handbook for the responsible return of ill-gotten gains precisely aims at drawing attention of policymakers to all these practical concerns. And now give the floor to Sarah to briefly conclude on.
Thank you very much. So we see that the new French restitution mechanism has high ambitions of transparency, of accountability, and of inclusiveness. What we, from our from experience from other practices abroad, we see that risks are high, as those principles remain needed. This is why we developed these indicators, and this is why we are sure that drawing lessons from those practices can help French practitioners, but from other countries as well, to really make the best choices when they will have to implement those principles in practice. And just to finish, the stakes are really high because France has confiscated more than 150 million euros to Théodore, and France will now have to return it to Equatorial Guinea, a country where there has been no political change, where we know that there is a really small civic space for CSOs, that most of the civic space has been captured by government control organizations. So the stakes are really high. The challenges are consistent, are critical, and they will require systematic solutions to ensure that the principles of transparency and accountability are implemented. And in our opinion, in Transparency International opinion, but I think I speak for most of CSOs here, it is only if these principles are actually materialized that the French restitution mechanism could really become a groundbreaking model for responsible asset return. Thank you very much.
Thank you so much. Thank you again for another very interesting presentation. Lots to think about there as well, and I'm really interested to hear about the way that this is developing. Just without further ado, then I would like to pass the floor to our last speaker, Dr. Igbigion, who is going to be talking about a new model for repatriating stolen assets. So without further ado, I hand over the floor.
Thank you very much. I'm sorry I am not in video. My internet connection is a bit unstable, so the audio streaming appears to be better. I have a set of slides here. Let me please enable me, the host, please enable me to the host. I'm disabled from screen sharing. Hello?
Yep, that's just been enabled now. Sorry for that.
Okay. 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 My presentation is entitled "A Case for a New Model for Repatriating Recovered Assets to Original Owners." I have a set of outline here. I have to do with one, the significance of asset return; two, current repatriation model; three, a case for a new model; then four, options for managing recovered assets; then five, conclusion. I will take them in turn. Of course, number one, significance of assets return. Yeah, it is publicly known that so much resources belonging to victim states are looted by their corrupt public officials and relocated to foreign jurisdictions, and that speaks to the economy. And with that, the economy is undermined, and of course, with return of assets or repatriation in sight, that would boost the economy one more time. And secondly, it is restorative. With the looting of the treasury of some of these victim states, that is injustice. And that is injustice. And of course, when there is restoration, that means that there is restoration of justice, there is restoration of assets to those who have been harmed by the initial looting. And that takes me to the United Nations Convention Against Corruption, 2003, which makes the return of assets a fundamental principle. The first speaker has spoken a lot, dwelt a lot on the legal, has analyzed a lot about the content of that Article 57, but that is noted. But suffice it to say here that the return of assets is a fundamental principle of the convention. And now, number two, current repatriation model. Current repatriation model, and that comes from recovery as well, is state-based. It is a reflection of the current Westphalia state system, whereby the state is the center of gravity, so to speak. The state is the owner, is the master of its destiny. It is the state that owns the assets, and it is the state that we have to, the victim state right now, the victim state will have to ask another state, the custodial state, the state in which the assets are located, for assistance. If the state does not, if the victim state does not initiate that move or that step, the custodial state may not, or does not have any duty, moral or otherwise, to intervene in anything like that. Of course, there is state sovereignty, and there is Article 2 of the UN Charter saying that no state has a right to interfere in the internal affairs of another state. The issue of plunder of resources by the corrupt officials of a particular state is a domestic affair. It is only when the assets have been relocated abroad that you introduce internationality into it. But essentially, the current repatriation model is based on the cooperation between the victim state and the custodial state, or the requesting state and the requested state. And that is the essence, by and large, of the provisions of the UNCAC, and that which requires states involved in recovery or repatriation to enter into some form of agreement, bilateral or otherwise, so that assets could be repatriated as and when due. And okay, and so because of that, many states have actually agreed, both the requesting and the requested states agreed through bilateral agreement or trilateral agreement or otherwise to restore assets back to the original owners. There are a few examples here between among Nigeria, Switzerland, and the World Bank. Then again, concerning the Abacha loot that Switzerland restored to Nigeria. There is also the one relating to the US, Nigeria, and Jersey agreement involving Abacha loot steel, $300 million. Then, yes, there was the MOU between the United Kingdom and Nigeria for the return of asset of 4.2 million pounds Ivory loot. And these are just examples, and the one between MOU among Switzerland, Kazakhstan, and the World Bank having to do with the return of $48.8 million. These are some agreements that have been entered into by the relevant states, and these agreements have enabled some states, especially the custodial states, the destination states, to reflect, to ensure that their fears and their concerns are taken care of before the assets are repatriated. But there are issues, there are matters arising in the current repatriation model. First is the issue of mismanagement of assets. We notice that even if agreements are entered into between the requesting and the requested states, the bottom line is that it is the requesting state that actually has to implement in the name of state sovereignty. And in all this, we find mismanagement of assets, because you see that most of these requesting states, they remain kleptocratic, and the public officials, relevant public officials, are corrupt. And because that character remains, so chances are that when the assets are returned to the requesting states, they find a way of just using the money, even if they cannot reloot the assets, of a way of wasting the money or not managing the assets properly. I have a clear example here, which has to do with Abacha loot of $321 million that Switzerland returned to Nigeria. There was a time the Swiss-based lawyer that recovered the assets did all that it ought to do for Nigeria to assess the assets. But when there were discussions as to the final release of the money to Nigeria, the current Nigerian Attorney General of the Federation said there were some administrative stuff that some lawyers had to do. He found out certain things that he asked some lawyers to do certain things administratively concerning the final release of the money by Switzerland to Nigeria, and order that 17 million US dollars be paid out of that $321 million to that Switzerland returned to Nigeria. That, to me, is a clear case of mismanagement of the assets, and it still speaks to the fact that Nigeria, despite some of the reforms around, it still has traces of kleptocracy. Then the second one has to do with relooting of the assets. In the case of Ivory loot, that the UK transferred or returned to Nigeria rather. There was a kind of reluctant or technical, if you like, technical reluctant in the sense that the assets were quite all right returned to Nigeria based on an MOU. But ultimately, the assets were not spent, were not restored to the ultimate victims. Nigeria is a federation. Nigeria is a federation of 36 states. And in the eye of international law, Nigeria has one voice, and that voice is spoken by the federal government. But it so happened that in the course of the negotiation between Nigeria and the UK, Nigeria made the UK to believe that Nigeria is a victim. I agree, Nigeria being the federal government is a victim in the eye of international law, but ultimately Nigeria was not the victim. There were victims within the victim, because this 4.2 million pounds were part of the asset that Ibori looted. Ibori, for emphasis, Ibori was just a state governor in one of the states in one of the 36 states of the federation, and that state is Delta State. So the governor got this allocation, this money, because he was the governor of that state. So when the assets were looted and now recovered in the UK and returned to Nigeria, everybody expected that that money, the resources, would go straight to that Delta State, to the victims for projects or developments in that state. But that was not done. The federal government and the UK agreed to use the money, the resources, in projects and programs distant from that state. In other words, these resources were spent on persons or on entities or on places that were far removed from the realm of that they were not victims. Now, and that to me is technical reluctant. The assets were diverted away from the ultimate victims. Also, in the case of the topical issue having to do with Equatorial Guinea, the typical kleptocratic state where you have Nguema or Obiang having looted the resources of the country and now living a lavish lifestyle and using all the resources everywhere to buy properties, expensive properties everywhere. And the Switzerland, US, and France, they've been involved in looking for the assets to freeze. Now some assets have been restored, have been recovered, and there is the plan that is afoot by Switzerland to restore assets. Some of the assets recovered, $27 million to Switzerland, to Equatorial Guinea. That, and with that kind of with the fact that the Equatorial Guinea remains a kleptocratic state, I just wonder how the return of the assets will not involve relooting. I just wonder how the asset will not be relooted, due for the one that the US wants to restore to Equatorial Guinea. And the last point here has to do with politics. I have mentioned the Ibori loot. The Ibori loot was restored to Nigeria. It is politics, pure politics, that prevented Nigeria from actually restoring the assets to those who were ultimate victims. Politics. So the convention, UNCAC, has stated it, that the victims should be those to benefit from the assets returned. But politics in Nigeria did not allow that. I will go to the next point. Okay, based on this, now I'm talking of a case for a new model. Why am I talking of this? Because the UNCAC and even the current practice has to do with the fact that return of assets is a bilateral issue. There must be a requesting state talking to the requested state. But the experience has been that there are instances where this possibility is slim, where this a state that ought to be a requesting state is not acting as such. And we are talking of kleptocracy, where a victim state ought to be able to ask for its assets from the custodial state. But the victim state is just an abstraction. It does not have the words or the will of its own. It is the directing will and mind, the high-profile public officials that can speak for it. If those officials are compromised, if they are culpable in the underlying plunder, then there is no way the victim, so-called victims, will originate any request for assistance, any request for the recovery of its assets. And the more assets are not recovered, the more you will not have assets to restore. So that is my point here. I'm talking of unilateral asset recovery by custodial states. These assets are located in foreign jurisdictions in the destination countries. And in many cases, there may be evidence or information as to where these assets are actually coming from. And the assets are there. But because there is no request coming from the victim states for obvious reasons, then the custodial state can just relax and say, well, on the basis of sovereignty, that's not my business. That is the issue. And so now, how do we now recover this pool of assets? Because the few recoveries, the few cooperation agreements we have are just they represent a small proportion of the assets that have been stolen or looted. Because those who are in the commanding heights, the public officials in the government officials in many of these states, they have vested interests, or their business associates, or their family relations. They won't bother to ask for the assets. For example, the family, the president of Equatorial Guinea didn't bother, did not originate any request to the US, to France, to other countries to recover the assets stolen or misappropriated by Obiang. It's not possible. So now we're asking for them. Fortunately, some states have taken the lead in going ahead to actually recover assets unilaterally. We've mentioned the case of Obiang, and even aside, the US has been involved. France and Switzerland have unilaterally done something to recover these assets. And even in the distant past, states, there have been instances where states have issued executive orders to freeze the assets of foreign sovereigns, and heavens didn't fall. And here we are talking about corruption, assets that have been looted from the victim states. They are located in the destination countries, and they are left to lie low there. And we are waiting for the victim states to request recovery or assistance recovery. That request will not come for obvious reasons. And what we are saying here is that the custodial states should think about how to vigorously help in recovering these assets. And they can do this. It is agreed that they will have difficulties doing that, but they will need evidence as to the source, establishing the origin of ownership and all that. Yes, but then that the evidence may not be forthcoming from the victim states. So does not make their unilateral approach to be impossible, provided they rely on information from other sources. For example, information could be sourced from a wide range of stakeholders, including third-party states, international organizations and agencies, even non-state actors, as to the character of the assets that we are talking about. Information, facts, and evidence relating to the assets we are talking about. I recall that if the US has the US has a program of kleptocracy program in which they invite persons or individuals with information relating to assets that have been plundered abroad and laundered into the US financial system to come forward with the information. So if these custodial states will look at this, if they do this, if they are able, if they source information from all these organizations, from all this variety of organizations, they will be able to get, I believe they will be able to get the evidence and the facts they need to recover, to unilaterally recover these assets, so much assets. And specifically, I refer to the role the non-state actors have been playing, and especially with what has been done in France by the TI International, based in France, and the Shepherd. What they have done, they actually started this this noise, so to speak, about the Obian's assets, another asset, before the French authorities now came in to intervene vigorously. So that is to show that non-state actors, wherever located, they have that network of influence, and they can actually be helpful in gathering information that will be helpful to custodial states. And talking about the justification, why should the custodial states be so involved in all the
Sorry, I'm just going to have to ask you to wrap up in just a minute or so, because we're kind of at the end of your time now. We just need to keep a bit of time left for the question section as well. Sorry to interrupt.
Have a minute?
Yeah.
Okay. Justification as to the justification for state involvement. I mentioned jurisdictional link, communitarian concerns, and recovered assets and foreign aid. Then the options for recovery. Now that should be restitution, pursuant to the convention, and also that involvement, third parties can be involved, could be involved in assets return. I mean, returning the assets. That I am not of the view that assets should be returned to the government, a kleptocratic government, or a government where the profile of the public officials there speaks about corruption. I am not, because that may amount to relooting. That it is better we use neutral parties or persons to disburse, to implement the programs and policies programs and projects that will be executed with the returned assets. And that is what is, and also the character of the project. The money that is being returned should not just be used on, there should be certain projects, legacy projects, that the assets should be devoted to, not on consumables, not on social investment that will make the government of the victim state to be sharing money, cash. That shouldn't be. And alternatively, if all these things, in addition to all this, the money may as well be kept in the territory of the custodial state that has recovered the assets until such a time that the condition is right for their return to the victim state. And I conclude by just recapping, and I'm saying here that the current state-centric asset recovery or reparation model, it gives huge opportunity to corrupt officials to undermine the recovery and the repatriation process. And therefore, it is advisable that the custodial states should take the bull by the horn to unilaterally recover, and of course, to do something about the repatriation as already suggested. Thank you.
Thank you so much for that really interesting presentation. I'm very sorry I had to cut you off there towards the end, but I think, yeah, I mean, there were lots of really interesting points that you discussed, and I think a lot of things also for us to discuss. We have around 5 minutes left. I propose maybe we just go over by 5 minutes so that we still have time for a break in between this session and the next one, but so we still have time for a few questions. I think there's been a couple in the chat. But maybe I can also just take my prerogative as a chair and just ask one first question. And yeah, I mean, it's directed towards Cecily. And I was just wondering, about the draft Office of the High Commissioner for Human Rights principle or guidelines on asset recovery. I was wondering if you've been involved in this process, how you see these principles, and if you have, what do you expect also about the chances of these being adopted? Are they kind of forgotten now? Or are they... Yeah,
it's been approved.
Oh, okay.
Yeah.
Great.
So that's good news, right? It took a really long time. So to answer your question, which I'm sorry I interrupted, I drafted the document and was involved in several stages of consultation about it. So that involved expert consultation and also consultation with states. Yeah, it took a long time for it to get to the desk of the High Commissioner, but she approved it at the end of last year. So it will be published. And I think the basic point of the document is to make this link between human rights law and asset recovery, and to explain how the two bodies of law are and can be mutually reinforcing, and how some of the tensions that exist can be resolved. Does that answer your question?
Yeah, great.
Briefly?
Thanks okay. So much. I mean, yeah, that's also great news to hear that they've been approved.
Yeah.
Yeah. So congratulations on that.
Yeah.
So
it's coming.
Okay, perfect. We have had a couple of questions in the chat. And we also, I see a hand up from Pedro at least. From the chat, I'm just trying to have a look through these now. Maybe in the meantime, I can have a quick look through those and I can pass the floor to Pedro to ask a question directly.
Thanks, Jackson, and thanks everyone. Very, very interesting. Just one question for Cecily. I understand Article 57 and the challenges, and I remember that first COSP in Bali and the disaster of trying to create that trust fund and everything else. My question is, what leverage do the countries that are holding the assets have in applying any conditionalities, which is the word of choice at the moment, when the entire case has been done by the victim country? Because the examples that we've been largely talking about, they presuppose that it was actually the country holding the assets that did the entire investigation and prosecution, or it was litigated in those countries, which gives them then the authority to condition how those assets are going to be returned. But if I have a sovereign decision based on an investigation that has largely been conducted by me, and I'm thinking of Tunisia in this case, how could the country holding the assets impose is a strong word, but suggest diplomatically to begin negotiations concerning conditions?
So I understand you to be outlining a scenario which would not fall under the narrow range of cases that require mandatory return. So where there hasn't been a request based on Article 55 of UNCAC, right? Right. So then, in theory, then the haven state that it has the money could impose conditions. There's nothing legally in UNCAC to stop that. Politically speaking, that's a very contentious way to go about things. And I myself think that there should be much more going on in this realm in terms of mediation. I think that to me, there's an unexplored potential here for mediators to help resolve these issues where Switzerland, for example, or the United States wishes to impose parameters, conditionalities on the return of assets in situations where there are perhaps valid concerns about how whether the funds will be re-corrupted, so to speak. Does that answer your question?
It does. I have a plethora of questions, but we don't have time. Can I just say one thing, 30 seconds? Yeah. I promise. Jackson, he's the host. I'm looking at him. Because Fabiano mentioned the Banco Santos case. And I remember on the earlier Banestado CC5 case, where there was it was just the money laundering, it wasn't corruption related, but it was a 50-50 split between a country that shall not be named to the north of Brazil and Brazil. And I remember this country came with a large WAD. These are conditions to return the 2 million in this case. And then when we went to return the 2 million back to that country, we did the same. And they said, we're not signing that. And it's like, okay, please explain the United States. Why do you refuse to sign something that is exactly that you gave to us? Yeah. Right. So how do you do that? Because I mean, it's in the end of the day, it's a two-way street, right? Countries have to accept that they might be on either end of that situation.
Yeah, and you could also argue under human rights law that this is I mean, until in practice, there's arguments that there's not conformity with economic and social rights, that there's meant to be technical assistance and international cooperation, and simply refusing or imposing that duty of cooperation.
Thanks a lot.
And back to you.
Yeah. So we had a question in the chat from Anna Jordanova, who asked, in countries where civil society does not have a relevant voice in general, does this mean that property assets should not be returned at all? And Cecily, I saw you already responded to this from your perspective, but maybe we could hear about how this would work in the French case. Yeah.
Yes, thanks. Sure. And actually, we are already facing such a situation because, as it was mentioned by Simeon, now France has confiscated Obiang's assets and Rifatal assets. So we are talking about returning assets towards Equatorial Guinea and Syria. So two complicated countries. It's the last we can say. In our opinion, and this is what we advocated for when we met decision makers, French parliamentarians, etc., there's no reason for the confiscated assets to stay in the French treasury. And there's always a way to return assets, even in complex and difficult contexts. There are experience with the Swiss, for instance, where assets have been returned in contexts where civil society organizations were, where in difficult contexts, and it worked. So I think we can work with diaspora. We can also find ways to to maybe finance grants for students, etc. There's, the limit is the imagination, and this should not prevent destination country, haven country, to not recover the asset and to not return them. Because if we, just to finish with that, if a country who recover assets just say, okay, this is not an ideal democracy there, and what are the criteria? It's highly subjective, I think. I do not recover them, and I just stay in my treasury. I think it would open the way for destination countries not to recover the assets. And we see that now most of the destination countries do not recover the assets. So if we let them having this option not to return them, I think it won't go in the right direction.
If I may just add to quickly complete Sarah's reply, we've been exploring too the idea that in circumstances where the civic space is kind of captured by in the country of origin, destination countries should also consider engaging a dialogue with civil society from the origin country, but established abroad. So, for instance, it's not because currently, let's say in Equatorial Guinea, you don't have a lot of CSOs being able to conduct independently their activities. It's not for that reason that you shouldn't, let's say, turn to CSOs abroad dealing with Equatorial Guinea issues and composed of citizens from Equatorial Guinea to discuss these matters.
Thank you so much. We're really running out of time, but I want to just raise one more question, which is from Christian. And this is, I think, maybe directed towards Cecily again. So in cases where countries are systematically failing to provide information on asset recovery process, are there ways we can use international human rights mechanisms to engage with their systematic failure to provide information?
That's a good question. Well, don't you think this could be raised within the context of, for example, the Universal Periodic Review that's carried out by the Human Rights Council? So within the context of the review of the human rights record of the country at issue, this could be raised as a practice which conflicts with particular treaty obligations. So I think that the human rights treaty bodies and the Human Rights Council are forums, potential forums in which this could be addressed. And these bodies already deal with corruption, so it wouldn't be a new issue per se. It hasn't been raised, but this particular issue hasn't been raised, but it could be.
Thank you so much. I think that really is all we have time for, because I want to give everybody a break before we have our next session, which is starting in 23 minutes. So yeah, I just want to start by thanking all of the speakers for the excellent presentations and a super interesting discussion. I mean, there was so much information. I think it was really yeah, it was really great and really a great start to this conference. So thank you all. Thank you also to the participants for participating, and for those who asked questions for your excellent question. I'm sorry we couldn't have time to go through any more questions that people had, but I'm sure we can also, if people want to get in touch with you directly, we can put them in touch with you if that's okay. And otherwise, I would say, yeah, enjoy the break, and we'll see you back again in just over 20 minutes for the next session, which is also looking to be super interesting. So thanks a lot, everybody.